Greetings and welcome back to part two of Memorandum of Law on the Name. When we left off at the legalities of all capital letter names. We could go on for hundreds of pages citing the legal basis behind the creation and use of all capital letter names. In a nutshell, fabricated legal persons, such as State of Texas, all capital letters, can be used to fabricate additional legal persons. Fictions arise from the law, not the law from fictions. Bastard legal persons originated from any judicial governmental actor that wishes to create them, regardless of whether it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation states, all of which are artificial corporate entities since they exist in abstract idea and construction alone. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. Federal government is not only created by it, but is also bound to operate within the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic United States of America Constitution. Was it created according to the lawful process or created outside of lawful process? Executive order and directives. For years, many have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all. Executive orders and directives. They are color of law. Without being valid laws of due process, these executive orders and directives have the appearance and semblance of law and look as if they are laws, but according to due process, they are not laws at all. Rather, they are laws based on fictional beings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code, rules, and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative, dare we say, laws. Lincoln established his executive orders 85 years after the independence of the United States. 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, without a date to reconvene, or without day. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Constitution. Solely in his capacity as commander-in-chief of the largest standing military the world has ever seen, known as the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more notorious than yeah. So, what are you going to do about it? Having a monopoly on currency, law, and what passes for government, and most of the world's firepower, the motto of powers that be is, we have got what it takes to take what you have got. Now, I'm going to do a little bit of ad lib here. And we're going to go off this memorandum for just a brief moment because I think it's an important time to articulate exactly what happened. You see, although the Congress adjourned sine die, they still had the authority to reconvene under their own power. And yet they opted to reconvene under an executive order, which meant that the Congress at that time then and there became the trusted advisors of the commander-in-chief. Keep in mind that we were in time of bankruptcy and a new charter was being formed. The reorganization of 1871 plan was in full manifest and swing. So Congress reconvening under an executive order, the Congress then and there becomes the advisors to the commander-in-chief, okay? When the Supreme Court, in its infinite wisdom, sat on its thumbs and did nothing about it, they became the administrators of the bankruptcy on behalf of the commander-in-chief, okay? That's what really happened. You do not have a judicial branch, an executive branch, and a legislative branch after 1871, ladies and gentlemen. And even quite frankly before that, as is clearly being articulated in 1861 with the executive orders. What you have is a despotic executive branch, which means everything is under commerce, which is exactly why the UCC was put in place. Because everything they are doing is business. And everything they're doing in a Admiralty Maritime Court setting is a private, for-profit, ad hoc corporation using codes, statutes, city ordinances, rules, and regulations to unjustly enrich their principals under the guise that it's the law. But you see, the reason they use the UCC is because they're engaged in commercial activity, negotiating securities, without duly informing you of what they're dubiously doing. Now, back to the memorandum at law. Legal fictions, laws, such as the Reconstruction Acts and the implementation of the Libra Code, okay, the Libra Code, it's very important to go read it. Might not seem like it at this moment in time, but I'm telling you, if you go read it, pay particular attention to Article 38, Article 31, and Article 2, because without Article 38 and 31 being upheld, Article 2 could never come to fruition. All right? Legal fiction, laws, such as the Reconstruction Acts and the implementation of the Libra Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. That's because we're now under martial law, military occupation. Nowhere in the Constitution does it say that the Constitution can be suspended, period. The power to create can never be greater than its creator. And the hierarchy goes God, man, government. Man created government, therefore government is subservient. Government created corporations. Corporations are what they were designed to lord over to ensure we, the people domiciled in the 10th Amendment, with all of our unalienable rights intact, not reserved. They're intact at all times. Okay? That's why the government was created, to safeguard we, the people, from the power of commercial and political gain, capitalism, the power of immense wealth manifest in corporations, being able to bend the law and the will of the people. And so government was put in place to ensure that egregious encroachment never came to be. Unfortunately for us, we fell asleep at the wheel. It's time to wake up. I'm here to help you out. Soon thereafter, and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on colorable, fictitious entities created arbitrarily out of nothing, without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules of rulership by force, conquest, originating from and existing in military martial law jurisdiction, which is had out of necessity. See, the law of necessity. Necessity trumps the law. That is a military maxim. All right? Military martial law jurisdiction. Jurisdiction of war. Win, lose interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid being eaten, killed, or destroyed. No law, lawlessness, complete absence of all lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity equals no lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence. No bona fide enforceable contract, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demand from self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military martial law jurisdiction, with the only law being the law of necessity, or the law of the jungle. The war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman reaffirmation of operational authority under the war powers begins. Now, therefore, I, Harry S. Truman, it's a false and fictitious assumed business name, hope you all are paying attention, President of the United States of America, acting, ladies and gentlemen, under and by virtue of the authority vested in me by Sections 5B of the Trading with the Enemy Act of October 6, 1917, 40 Statute at Large, 415 as amended, Section 5B of Appendix Title 50, Military Title, Title 50, United States Code, and Section 4 of the Act of March 9th, 1933, that's the Bankruptcy Act, that's the Federal Reserve Banking Act, that's the abrogation of the Gold Clause, that's the National Banking Holiday, March 6th through March 9th. 48, Statute at Large 2, Sick Transit Rights, Substance, Truth, Justice, Peace, and Freedom in America, the land of the free and the home of the slave. The brave. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until mid-19th century, was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe v. Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e., executive order and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida Statutes, 1999, Title I, Chapter 2, at subsection 2.01, common law and certain statutes declared in force in states. It states, the common law and statute laws of England, which are of a general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be of force in this state, provided the said statutes and common law be not inconsistent with the Constitution and laws of the United States and the acts of the legislator of this state. History, S. Period 1, November 6, 1829, Revised Statute 59, GS 59, RGS 71, CGL 87. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes, ordinances, based on executive order and not the due process specified within the organic Constitution. Existing and functioning under the laws of necessity ab initio, they are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e., organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanisms to accomplish any result or results other than disruption, conflict, damage, and devastation. The established maximum of law applies. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. Applying it all to current laws. An established maximum of law states the importance of the name. In order rightly to comprehend a thing, inquire first into the names. For a right knowledge of things depends upon their names. Title III, Pleadings and Motions, Rule 9A, Capacity, Federal Rules of Civil Procedure, states, in pertinent part, when an issue is raised as to the legal existence of a named party or the party's capacity to be sued, or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement, correction, for all parties of an action of purported law. However, the current courts cannot correct this, since they are all based on presumed, assumed, fictional law and must use artificial juristic names. Instead, they expect the lawful Christian man and woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumptions. That you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all caps name. One angle of approach is found in the requirements for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statute, Chapter 22, subsection 403. Now, this may have been altered and changed since this memorandum was created. This was, keep in mind, I had this back in 2019. So inevitably, they say the law is fluid. That's because every time we make profound discoveries like this and draw it to their attention, they quickly repeal, alter, amend, or change, or move it somewhere. Okay, just because it says it's repealed doesn't mean it's been abolished. It just means they peeled it from one page and stuck it in another chapter somewhere else, all right? Because that's what these people do. They practice manipulation. They are narcissistic, lying, looting, rat, weasel, bastards in the woodpile, pieces of shit, all right? And some of us were given a big set of testicles and a fucking voice like a lion to sound off like we got a pair and let other people know, let God's people know we ain't putting up with this shit. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceeding his true name is discovered, it must be inserted in the subsequent proceedings referring to the fact of his being charged by name mentioned in the indictment or information. American jurisprudence in general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2D at Judgments, subsection 100, parties. A judgment should identify the parties for and against whom it is rendered with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the person for and against whom the judgment is rendered. Technical deficiencies in the naming of the person for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnotes numbered and cites are omitted. When we return, we'll be talking about the present situation in America. Thank you for joining me. And again, we're going to attempt to keep these videos short, sweet, concise, and to the point for your viewing and audio pleasure. Thanks again for joining me, and we'll talk real soon.